Thank you, Mr. Chairman. Thanks to all of you for being here today. This is such an important topic, and I share the passion that's been expressed by my colleagues on both sides of the aisle here. These are things that we need to address. In the past, there have been a handful of factors that have at times slowed progress, or in some cases even reversed it. Some of them are technical, others are constitutional. Sometimes the technical and the constitutional merge. As you're aware, in order to survive a First Amendment challenge, where the First Amendment is implicated, if you've got a government action that interferes with free speech, you've got to be able to survive strict scrutiny, which means that you've got to show that the government action at issue is directed at something as to which there is a compelling state interest. A compelling governmental interest must be the object of the legislation, and it must further that compelling state interest in the least intrusive, least restrictive means, through the least restrictive means possible. At times this has become a problem, as we learned in 1997 in a case called Reno versus ACLU. In that case, the Supreme Court of the United States invalidated provisions of the Communications Decency Act, provisions that would have prohibited the transmission of certain indecent content to minors. Now, in that case, as I recall, the Supreme Court concluded that the online harm and the risk of online harm to children was itself a compelling governmental interest, but that the provisions at issue didn't provide the least restrictive means to achieve that compelling state interest. Specifically, the court found that the age verification process for children at the time simply wasn't viable and would potentially prohibit access of others who should not be prohibited from accessing such content. Now, that was back in 1997. 1997, I think, was the year I purchased my first cell phone, and it was a relatively decent phone at the time. It just made phone calls. It didn't do anything else, nothing else at all, and we were, of course, a decade away from anything resembling an iPhone. But since then, things have changed. So, Professor Campbell, in your view, has technology advanced sufficiently since 1997 such that age verification is now a reality in a way that it might not have been then? Could we overcome this hurdle now?
I can't really speak so much to technology. I do know that as part of this data collection that companies often will infer, or these advertising networks will be able to infer the age of the users, so that it may well be much, certainly it would be more possible today than it was in 1997. And also, there's just so many more kids online and everyone online using it for so many different purposes, so that in just so many ways that the world is completely different than it was in 1997.
From that, one could certainly argue that our ability today to use the least restrictive means of furthering a compelling state interest is significantly enhanced relative to what it was 24 years ago.
Yes, I think so, but I also want to point out that commercial speech, at least it's deceptive, is not permitted as to children. We with children are different than adults in that we as adults have some responsibility for their well-being, and so there's certain things that we would not permit to be regulated as to adults, we do permit to be regulated as to children.
Sure.
And so
once you enter into the territory of Central Hudson, then if it's deceptive, you may have other tools that will not themselves trigger strict scrutiny.
That's correct.
Now, online platforms gather a lot of data with regard to their users, understandably so. This is their business. They want to understand. They want to make sense of the marketplace in order to facilitate targeted advertising. That's how many, if not most of them, make a living. But I am concerned about what that can mean at times with respect to children and how they target children and what they're doing or not doing to protect children. Baroness Kidron, do online companies know, or if they don't know, should they know? Should they be expected and required to know the age of the minors who have profiles on their respective platforms?
Yes, Senator. I think if I could just point at something that happened a couple of weeks ago in Australia, where researchers asked to find 13 to 17-year-olds with an interest in alcohol, smoking, gambling, extreme weight loss, fast foods, online dating services. Those were 13 to 17-year-olds. And they were then able to fabricate ads mentioning prizes, cocktails, and asking them if they were summer ready. You see how insidious it is. So it's not even just should they know, could they know, to which it is an unequivocal yes. It's even when they do know, they're not treating them properly. And if I might also just say narrowly to your point that you just asked previously, is Five Rights recently wrote a report about age assurance. How do they know how old we are? And I have sent it to the committee. And I think what is absolutely true, and your observation is very sophisticated. It is indeed the case that things have changed. We do have technology. What we don't have is governance, transparency, and an agreement about what age assurance should be, how it should be properly deployed. So I think the answer to both your questions is, you know, we do have the means, we don't yet have the will.
Mr. Chairman, I realize my time's expired. Could I ask one follow-up question
Sure.
that leads naturally? Thank you very much. Baroness, I'd like to go back to you for a moment and follow up on an observation you just made. I've learned a lot about this from a number of experts in the field, and especially my friend Melissa McKay from Utah, who's done a lot of work educating parents and children about the risks associated with content. It can be obtained online, very often on, through social media platforms by children. Sometimes the content is delivered to them with full knowledge of how old they are, because of the fact that when they open an account, they're required to provide certain information about their age. And even with that, sometimes one could argue because of that, they receive awful content delivered to them, knowing what they have. And yet, these apps, these social media platforms often operate through apps that are themselves subject to app age appropriateness ratings on the Google App Store and also on the Apple App Store. And in many instances, these age appropriateness app ratings on the app stores indicate that the apps themselves are suitable for children, in other cases for teenagers, including young teenagers. So why is there such a disparity sometimes between the app's listed age appropriateness rating and the content available on that platform, and sometimes sent to a minor, to a child on that platform? Why the disparity?
Yeah, I mean, well, I think you maybe needed to ask TikTok if only they would show. No, I think the truth is, in fact, I should revise that and say Google and Apple. I have raised this question in Parliament. I have raised it more than once, and I think it is extraordinary that we do not have a regulation or a law that says the App Store must give the same age rating as the terms and conditions. But in fact, we go on consistently and find many apps that are labeled one thing, 9, 10, you know, very young ages, that then turn out to be 16 and 18. And it is something I will be turning my attention to, and I hope it's something the committee will turn its attention to. I think the other thing that I would like to say to you is that recently we did some research. Again, we'll be publishing it shortly, but it was the case that we could see a child being targeted with actually government safety information, but that same child was being targeted with self-harm material, in one case, very aggressive adult pornography, and so on. And I think this point that I'm trying to make is Yes, we can find out their children, and there are new ways of looking at age assurance that are data light and do not interfere with other users. But also, we have to extend and put in protections for those users that they know are children. I mean, this is just essential.
Thank you, Baroness. Really appreciate that, and I would love to work with you in that effort. Thank you, Mr. Chairman.